I never thought I'd be the type to own a home in a gated community. As a retired military veteran who valued independence above all else, the idea of having neighbors dictate what I could and couldn't do with my property seemed antithetical to everything I stood for. But when my wife Elaine saw the listing for a charming craftsman in Evergreen Estates, her eyes lit up in a way I hadn't seen since before her diagnosis. "This is it, James," she whispered, squeezing my hand as we stood in what would become our living room. "We can watch the grandkids play in that backyard. We can plant those roses I've always wanted. How could I say no?" Within a month, we had signed the papers, and I was writing a check for our first HOA dues. A reasonable $220 monthly fee that supposedly covered landscaping for common areas, snow removal, and maintenance of the community pool and tennis courts. The community looked immaculate, with its manicured lawns and tasteful stone entrance. Our neighbors seemed friendly enough, though several mentioned the HOA president in hushed tones. "Just stay on Margaret Holloway's good side," our next-door neighbor advised while helping us unload the moving truck. "She runs a tight ship." I would soon learn just how tight. Margaret Holloway was a former corporate attorney who had apparently redirected all her litigious energy into running the Evergreen Estates HOA with military precision. I first encountered her at the mandatory new homeowner orientation, where she handed me a 3-ring binder containing 147 pages of rules, bylaws, and covenants. "I suggest you familiarize yourself with these immediately," she said without smiling, her pearl necklace gleaming under the community center's fluorescent lights. "Ignorance of the rules is no excuse for breaking them." I nodded politely, thinking the binder would make a fine doorstop. That was my first mistake. 3 weeks after moving in, as Elaine was still unpacking our kitchen, a crisp white envelope appeared on our door. Inside was an official notice from the Evergreen Estates HOA citing us for unapproved exterior decoration installation and demanding immediate removal of the item in question. A small American flag I had placed by our front door. Seriously. I showed the notice to Elaine. "It's a 6-inch flag. I served under that flag for 22 years. Maybe as a form we need to fill out," Elaine suggested. There was. In fact, there was an entire application process for flag displaying, including a requirement that all flags be approved by the Architectural Review Committee, which, coincidentally, was chaired by none other than Margaret Holloway herself. Little did I know, this minor flag incident was just the opening salvo in what would become the most expensive war Margaret Holloway ever waged. The flag issue should have been simple. I completed the required exterior modification request form, attached the requested photos of the flag and its proposed location, and even included a copy of the Federal Freedom to Display the American Flag Act of 2005, which specifically prohibited HOAs from restricting homeowners from displaying the American flag. 2 weeks later, I received another envelope. My application had been denied due to improper mounting hardware and non-conforming dimensions. The denial letter was signed by Margaret, along with a new fine of $50 for continued non-compliance. When I called the HOA office to speak with Margaret, her assistant informed me that she only addressed homeowner concerns at monthly board meetings. The next one was 3 weeks away. "This is ridiculous," I told Elaine that evening. "It's a flag, not a billboard." "Try to stay calm," she advised, though I could see the worry lines forming on her forehead. Stress wasn't good for her condition. "Let's just take it down for now." I reluctantly removed the flag, but decided to attend the next board meeting. I arrived early, armed with my 3-ring binder, and highlighted copies of the federal law. As other homeowners filtered in, I noticed they all seemed tense, sitting rigidly in their folding chairs and speaking in whispers. Margaret entered precisely at 7:00 p.m., flanked by 4 other board members who looked more like loyal lieutenants than neighbors. She wore a tailored navy suit with the HOA logo pin on her lapel. When my turn came to speak during the open forum, I calmly presented my case about the flag. "Mr. Reynolds," Margaret interrupted before I'd even finished. "The board is well aware of federal statutes. However, our community has aesthetic standards that must be maintained. Your mounting bracket was brass. Our guidelines clearly state that all exterior hardware must be brushed nickel to maintain community cohesion. It's a $12 bracket that no one can see from the street," I countered. "Rules are rules, Mr. Reynolds." Her smile never reached her eyes. "They apply to everyone equally. That's what makes Evergreen Estates special, our commitment to standards." Several homeowners nodded in agreement. I noticed one woman actually writing down "commitment to standards" in her notebook, as if it were a profound statement. Before I could respond, Margaret moved on to the next agenda item. My flag issue was dismissed without resolution, my fine still standing. As I left the meeting, one of my neighbors patted my shoulder sympathetically. "You're new," he whispered. "You'll learn to fly under her radar." We all do. I should have heeded his advice. Instead, the following weekend, I installed a new flag bracket, brushed nickel, exactly as specified, and raised my flag once more. 3 days later, I received not just a notice, but a formal violation letter, complete with photographs of my house taken from multiple angles. The new infractions. My grass was 5.5 inches tall, maximum allowed 4.5 inches, and the newly installed flag was mounted 68 inches from ground level, required height 72 inches. The combined fines totaled $175. That night, I started documenting everything. Something told me this wasn't about flags or grass height. Margaret Holloway had found her new target. Over the next 3 months, the notices kept coming with astonishing regularity. A $100 fine for leaving our garbage can visible from the street. It had been out for 30 minutes past the allowed window. A warning about unauthorized vegetation. The rose bushes Elaine had planted in our backyard, which apparently required prior approval. A $250 fine for non-compliant exterior lighting. I had installed a motion sensor security light after a series of car break-ins in the neighborhood. Each violation seemed more petty than the last. When I disputed them at the monthly meetings, Margaret would cite chapter and verse from the regulations, always with the same condescending smile. The breaking point came when our next-door neighbor, Bill Chen, received a notice about his ethnically non-conforming landscaping. Bill had planted a small Japanese maple in his front yard, a tree specifically listed as approved in the HOA guidelines. "She's targeting anyone who speaks up," Bill told me over beers on my patio, which, according to Section 7.32 of the HOA guidelines, was only permitted between the hours of 10 a.m. and 8 p.m., with no more than 4 guests. Last month, the Garces got fined because their Christmas lights were up 3 days past the January 6th deadline, even though the husband was in the hospital with pneumonia. We soon discovered we weren't alone. A pattern was emerging. Homeowners who questioned Margaret or her board would suddenly find themselves under intense scrutiny, with violations appearing for issues that had been ignored for years. "She's been president for 6 terms, Bill explained. "No one runs against her because anyone who tries suddenly finds themselves facing thousands in fines or threats of liens." The situation took a darker turn when Elaine's health worsened. Her doctor recommended a wheelchair ramp for our front entrance, a modification I dutifully submitted for approval. The request was denied. According to Margaret, ramps were visually disruptive to the architectural harmony of the street. She suggested we use the garage entrance instead, which would have required Elaine to navigate 3 additional steps and a narrow doorway. "This isn't just petty anymore," I told Bill after showing him the denial. "This is illegal. The Fair Housing Act clearly protects modifications for disabilities." "Good luck proving it," Bill sighed. Margaret's a former lawyer. She knows exactly how far she can push before crossing legal lines. I installed the ramp anyway, using designs that matched our home's exterior perfectly. The response was swift. a special emergency meeting of the board was called, and I received a violation notice with a $500 fine, along with a threat of daily accumulating penalties until the unauthorized structure was removed. That night, while helping Elaine up the disputed ramp, I noticed something unusual: a white SUV slowly driving by our house, the driver clearly taking photos. The vehicle had the Evergreen Estate Security logo on its door. They're monitoring us, I realized with growing anger. 2 days later, I came home to find a compliance inspection notice taped to our door, informing us that representatives of the HOA would be entering our backyard the following day to assess reported violations. According to the fine print in our HOA agreement, they had the right to enter the property, but not without 72 hours notice. They were coming anyway, notice period be damned. That was when I decided, if Margaret Holloway wanted a wall, I would give her one. The compliance inspection was nothing short of a raid. While I was at a doctor's appointment with Elaine, 3 HOA representatives, including Margaret herself, entered our backyard and spent nearly an hour photographing every conceivable angle of our property. Our security camera caught Margaret pointing at Elaine's rose garden, shaking her head disapprovingly, and making notes on her clipboard. The other 2 committee members nodded obediently, occasionally taking close-up photos of trivial items: a garden hose not fully wound on its reel, a bird feeder hanging from our oak tree, a slightly weathered cushion on a patio chair. When we returned home, a fresh violation notice was already on our door, citing 7 new infractions with fines totaling $1,750. Among the violations was unauthorized surveillance equipment, or security cameras. She's citing us for the very cameras that caught her trespassing, I told Elaine, who sank into her wheelchair, exhausted from her treatment. Maybe we should just sell, James, she suggested quietly. This house isn't worth your blood pressure. I might have considered it if not for what happened next. While reviewing our security footage more carefully, I noticed Margaret taking photos not just of our yard, but through our windows. One frame clearly showed her peering into our sunroom, her camera pointed directly at Elaine's medication organizer on the side table. My blood ran cold. This wasn't just harassment, it felt invasive, predatory. The following day, a certified letter arrived from the HOA's attorney, informing us that due to our continued and willful non-compliance, the board was initiating foreclosure proceedings on our home. According to the letter, our accumulated fines, now mysteriously totaling over $7,000, gave the HOA the right to place a lien on our property. They can't actually take our home for some petty fines, Elaine said, her voice shaking. But a quick internet search revealed the horrifying truth. In our state, HOAs did indeed have the power to foreclose on homes for unpaid dues and fines, often with less oversight than banks faced when foreclosing on mortgages. That night, I barely slept. I kept thinking about Margaret's smug face as she photographed our private space, about Elaine's roses that might be torn out, about the home we had purchased for our retirement now being threatened because of a power-hungry board president with a personal vendetta. The next morning, I received a text from Bill. Check your email. You need to see this. The email contained a forwarded message that had accidentally been sent to all homeowners instead of just board members. In it, Margaret outlined her strategy for dealing with problem residents, specifically naming our family and 3 others who had disputed her authority. Continued pressure through rigorous enforcement will either force compliance or compel them to sell, she had written. Either outcome benefits property values and community standards. There it was in black and white. Margaret was deliberately targeting specific homeowners, using the HOA's enforcement powers not to maintain community standards, but to drive out anyone who challenged her authority. I printed the email, hands shaking with rage and something else, determination. For the first time since this ordeal began, I had tangible evidence of discriminatory enforcement. I'm not running from this fight. I told Elaine, taking her hand in mine. This ends now. I reached for my phone and called the one person I had hoped to avoid involving. My son-in-law, Michael, a civil rights attorney specializing in housing discrimination. Michael, I said when he answered, I need your help. And I need you to bring everything you've got. Michael arrived the next day, his BMW pulling into our driveway precisely as another violation notice was being taped to our door. This one for unauthorized vehicle in temporary parking. Our daughter's car, which had been parked in our driveway for less than 2 hours while she visited. They're not even trying to be subtle anymore, Michael observed, taking the notice and adding it to the growing file of evidence he'd started after our phone call. For 3 days, Michael camped out in our guest room, reviewing every notice, email, and HOA regulation. He interviewed neighbors, examined financial records, which, as a homeowner, I had the right to request, and meticulously documented the pattern of selective enforcement. What he uncovered was more disturbing than even I had imagined. This goes beyond harassment, Michael explained as he laid out documents across our dining table. Margaret has been using the HOA as her personal fiefdom for years. Look at these financial records. Selective bidding for contracts, many going to companies with connections to board members. The landscaping company that maintains common areas, owned by her brother-in-law. But the real breakthrough came from an unexpected ally, Diane Foster, the HOA's former treasurer who had resigned 3 years earlier. I couldn't be part of it anymore, Diane told us over coffee, her voice barely above a whisper despite sitting in our kitchen. Margaret has been embezzling funds for years, disguising personal expenses as community improvements. That koi pond in the community center. Half those funds went to renovating her vacation home in Aspen. Diane provided bank statements, check copies, and emails that painted a damning picture not just of discrimination, but of financial fraud and breach of fiduciary duty. Armed with this evidence, Michael crafted a multi-pronged legal strategy. A federal housing discrimination claim based on the denial of Elaine's wheelchair ramp, a civil rights violation for selective enforcement targeting homeowners who opposed Margaret, a class action lawsuit on behalf of all homeowners for financial mismanagement and fraud. Before we file, Michael advised, we need to give them one chance to back down. Sometimes the threat of exposure is enough. I wasn't convinced. She's too arrogant to back down. Trust me, Michael insisted. We need to establish that we attempted to resolve this amicably. It strengthens our position if this goes to court. Michael drafted a detailed letter outlining our allegations, the evidence in our possession, and our demands. Immediate cessation of all enforcement actions against us, removal of all fines, approval of the wheelchair ramp, and Margaret's resignation from the board. The letter was delivered by courier the following morning, timed to arrive during the board's monthly meeting. 3 hours later, Margaret appeared at our door, alone and without her usual clipboard. Her face was ashen. This is slander, she hissed, waving Michael's letter. I could sue you for defamation. Please do, Michael replied calmly. Discovery would be fascinating. For a moment, I thought she might actually back down. A flicker of uncertainty crossed her face, but it quickly hardened into resolve. You have no idea who you're dealing with, she said. I've handled bigger threats than some small-town lawyer and his father-in-law. After she left, Michael turned to me with a grim smile. She's scared, but she's also dangerous now. We need to move quickly. The next day, we filed all 3 lawsuits simultaneously. By evening, the story had been picked up by local news. HOA president accused of discrimination and fraud in federal lawsuit. Within hours, my phone was ringing non-stop. Neighbors I'd never spoken to, all with their own Margaret horror stories. Michael set up a dedicated line and email address to collect testimonials, and by the end of the week, our class action had grown from 4 plaintiffs to 37. The community I thought had been united behind Margaret's standards had actually been silently suffering under her reign of terror. Now, finally, they had a chance to fight back. Margaret's response came swiftly and viciously. Within 48 hours of our filing, every plaintiff in the lawsuit received violation notices for infractions both trivial and imagined. Margaret had declared total war, but this time we were ready. Margaret's scorched earth policy backfired spectacularly. Each new violation notice only strengthened our case of retaliatory enforcement and brought more homeowners to our side. By the 2-week mark, over half the community had joined the class action, and Michael had secured an emergency injunction preventing the HOA from issuing new fines or pursuing collections on existing ones. The first real crack in Margaret's armor appeared at the emergency board meeting she called to address the lawsuits. Our neighbor Bill attended and secretly recorded the proceedings on his phone. "We need to present a united front," Margaret insisted to her increasingly uncomfortable board members. "These lawsuits are frivolous and will be dismissed." But when the HOA's attorney, hastily brought in from a prestigious downtown firm, reviewed our evidence, his assessment wasn't what Margaret wanted to hear. "The discrimination claim alone could cost us millions," he warned. "And if these financial allegations can be proven..." He left the sentence unfinished, but his meaning was clear. For the first time, board members began questioning Margaret's leadership. Vice President Tom Wilson, who had been Margaret's staunchest ally, asked the question no one had dared voice before: "Should we consider a settlement?" Margaret exploded, accusing Tom of disloyalty and threatening to reveal certain indiscretions regarding his own property modifications. The threat silenced him, but the damage was done. Seeds of doubt had been planted. Those seeds bloomed the following week when the local newspaper published an exposé on Evergreen Estates, featuring interviews with former board members and contractors who corroborated Diane's allegations of financial impropriety. The article included photographs of Margaret's Aspen renovation side by side with the community center's co-pond, highlighting the identical stonework and fixtures paid for by HOA funds. The community reaction was immediate and furious. An impromptu meeting in our cul-de-sac drew over 100 homeowners, many calling for Margaret's resignation and a complete board overhaul. Margaret, however, refused to step down. Instead, she called an emergency meeting of her own, limiting attendance to members in good standing, effectively barring anyone who had ever received a violation notice, which included most of her critics. At this closed-door session, she convinced her remaining loyalists to approve a special assessment, an additional $2,000 per household to cover unforeseen legal expenses. The assessment would be due in 30 days, with late payments subject to the same collection procedures as regular dues. It was a desperate money grab, designed to replenish the funds she had misappropriated before a court-ordered audit could expose the full extent of her theft. The assessment notice arrived in our mailboxes the next day. Rather than intimidating homeowners, it galvanized them. That evening, a convoy of cars paraded through Evergreen Estates, honking horns and displaying hastily made signs. "No Margaret" and "Stop the ETF." The protest ended at Margaret's immaculately landscaped home, where homeowners placed their assessment notices in a pile on her doorstep and took turns signing a petition demanding her immediate resignation. Margaret called the police, claiming she felt threatened by the peaceful protest. When officers arrived, they found no laws being broken, just angry homeowners exercising their right to assemble. The officers left without taking action, but not before one of them was caught on camera telling a homeowner, "My HOA's pretty bad too, but nothing like this." The video went viral locally, bringing news vans to our once quiet community. Margaret retreated behind her closed blinds, refusing to comment. The next blow came from within. 3 board members, sensing the inevitable collapse of Margaret's regime and fearing personal liability, resigned simultaneously. In their joint resignation letter, leaked to both homeowners and the press, they expressed grave concerns about financial management and enforcement practices, and pledged to cooperate with any investigation. With the board lacking a quorum, Margaret could no longer authorize expenditures, including payments to the high-priced attorney she had retained. The firm withdrew from representing the HOA, citing irreconcilable differences with leadership. Margaret was now effectively alone, but like all common predators, she prepared for one final, desperate attack. Dawn broke over Evergreen Estates with the sound of power tools. Homeowners emerged from their houses to discover a crew of workers erecting a chain-link fence around our property, directly through Elaine's rose garden. Margaret stood supervising, clipboard in hand, a triumphant smile on her face. Emergency security measure, she announced to the gathering crowd. Authorized under Article 12, Section 3 of the bylaws. The board may take immediate action to secure common areas from imminent threats. This isn't a common area, I protested, watching in horror as Elaine's carefully tended roses were trampled. This is our private property. Margaret's smile widened. Actually, your property line ends 3 feet from your foundation. This strip is technically a utility easement, which falls under common area jurisdiction. She was twisting the rules beyond recognition, but the workers continued regardless, following her pointing finger as she directed them to encircle our home. Michael arrived within the hour, accompanied by a county surveyor and a court officer bearing an emergency restraining order. The fence construction halted, but not before significant damage had been done to our landscaping. She's gone too far this time, Michael assured us. Destruction of private property, trespassing. We're adding criminal charges. The confrontation had drawn nearly the entire community. Neighbors who had once avoided each other now stood united, documenting everything on their phones. Margaret, however, seemed eerily calm despite being clearly outnumbered. You think you've won, she addressed me directly, her voice carrying across the now silent crowd. But Evergreen Estates is mine. I built this community. I protected it from people like you who want to turn it into just another declining suburb. This was never about property values, I replied. This was about power. Your power. Same thing, she snapped. Without control, standards slip. Without standards, everything falls apart. You'll see. As if on cue, her phone chimed. She checked the message, and a slow smile spread across her face. It seems the county has concerns about certain structural modifications to your property, she announced. Specifically, a wheelchair ramp installed without proper permits. Michael's face darkened. That's impossible. We filed all the necessary permits. Did you? Margaret's voice dripped false concern. Because according to County Inspector Davis, no such permits exist in their system. Such a shame. An inspector will be here tomorrow to assess the violation. I believe unauthorized structures may need to be removed immediately, regardless of their purpose. She had called in favors at the county level, a new attack vector we hadn't anticipated. Before Michael could respond, an unexpected voice cut through the tension. That won't be necessary, Margaret. County Commissioner Helen Rivera emerged from the crowd. The homeowner standing beside her, one I recognized from community meetings but had never spoken to, had apparently called her directly. Ms. Holloway, Commissioner Rivera continued, I've received some disturbing reports about permit interference in this community. Specifically, multiple homeowners claimed their properly filed permits were mysteriously withdrawn or lost. The county takes such allegations very seriously. Margaret's face flushed. I don't know what you're talking about. Really? Because Inspector Davis just confirmed that the Reynolds ramp permit was properly filed last month, then withdrawn yesterday, by someone claiming to represent the homeowner. The withdrawal request came from an email address registered to the Evergreen Estates HOA. The crowd gasped collectively. Margaret's manipulation of county systems crossed a line from HOA overreach into potentially criminal fraud. Furthermore, Commissioner Rivera continued, I've just come from a meeting with the district attorney. based on evidence already provided by Mr. Reynolds' attorney, they're opening an investigation into financial irregularities involving HOA funds. Margaret's clipboard clattered to the ground. For the first time since this ordeal began, she seemed genuinely frightened. "This is a misunderstanding," she stammered. "The board authorized all expenditures. Everything was approved." "By a board you controlled through intimidation," Michael interjected. "A board that has now resigned and provided sworn statements about your methods." The commissioner handed Margaret an official-looking envelope. "This is a preservation notice. You are legally prohibited from destroying, altering, or hiding any HOA records, electronic or physical. DA investigators will be collecting all financial documents tomorrow morning." Margaret's carefully constructed facade finally cracked. "You can't do this to me," she hissed, her composure evaporating. "I own this neighborhood. I own all of you." As if to punctuate her meltdown, a police cruiser pulled up to the scene. 2 officers approached, faces grim. "Margaret Holloway," one asked, "we need you to come with us. There are some questions regarding inappropriate access to county permit systems." As Margaret was escorted to the police car, the community she had terrorized for years watched in stunned silence. Her parting glare promised this wasn't over. But the balance of power had irrevocably shifted. That evening, as workers removed the partial fence from our property and neighbors helped Elaine salvage what remained of her roses, a strange calm settled over Evergreen Estates. "Is it really over?" Elaine asked as we sat on our front porch, watching the sun set on what had been the most extraordinary day in our community's history. "The HOA fight? Yes," I assured her. "The legal battle? That's just beginning." The trial lasted 6 weeks, but Margaret's reign had effectively ended the day of her arrest. Released on bail but barred from entering Evergreen Estates or contacting any residents, she was forced to watch from afar as the community she had ruled with an iron fist transformed without her. Michael's legal strategy proved devastatingly effective. Rather than pursuing separate tracks for each complaint, he consolidated everything into a single case that painted a comprehensive picture of Margaret's abuse of power. The evidence was overwhelming. Financial records showing over $650,000 in misappropriated funds over 7 years, testimony from former board members about intimidation tactics, and selective enforcement documentation of systematically targeting anyone who questioned her authority, evidence of her interfering with county permits to further her vendettas, proof of her using HOA resources to monitor and harass specific homeowners. Most damning were the recordings of Margaret's own words, captured by neighbors during her final meltdown. "I own this neighborhood. I own all of you." The defense tried to paint Margaret as a dedicated volunteer who perhaps became overzealous in protecting property values. But this narrative collapsed when prosecutors revealed her financial motives. She had been quietly buying and flipping homes within the community, using her insider knowledge and enforcement powers to force distressed sales, then waiving restrictions for her own properties. When the verdict finally came, it exceeded even Michael's expectations. The court found in our favor on all counts, awarding $2.3 million in damages, $1.8 million in compensatory damages to be distributed among all homeowners, plus $500,000 in punitive damages specifically to our family for the disability discrimination and targeted harassment we had endured. More importantly, the judge issued a sweeping injunction against the HOA, placing it under court supervision for 5 years, and ordering a complete revision of all bylaws with direct homeowner input. Margaret herself faced separate criminal charges for fraud, embezzlement, and misuse of government systems. Rather than risk prison time, she accepted a plea deal, full restitution, 5 years of probation, and a permanent ban from serving on any HOA board or managing any property association. As for Evergreen Estates, the community underwent a remarkable transformation. An interim board was elected with a mandate to rebuild from scratch. The first order of business reducing monthly dues by 40% once the financial hemorrhaging stopped. The oppressive rule book was replaced with a slim 10-page document focused on basic maintenance standards and democratic governance. The Architectural Review Committee was disbanded entirely, replaced with simple guidelines that respected homeowner autonomy while maintaining reasonable community standards. Bill Chen became the new board president, running on a platform of transparency and minimal interference. His first official act was to approve all previously denied reasonable modifications, including wheelchair ramps, solar panels, and yes, properly displayed American flags. Elaine's rose garden, partially destroyed during Margaret's last stand, became a symbol of renewal. Neighbors who had once avoided eye contact for fear of drawing Margaret's attention now worked together, replanting the damaged section with contributions from their own gardens. What had been Elaine's private joy became a community project, with different varieties representing the diversity of families now flourishing without Margaret's oppressive uniformity. On warm evenings, our patio, now hosting gatherings well past the formally mandated 8 p.m. curfew, became an informal town square where neighbors debated improvements and shared stories of the Margaret years, with equal parts humor and disbelief. The settlement money, while substantial, wasn't the true victory. For most homeowners, their share after legal fees amounted to several $1,000s, enough to undo some of Margaret's damage by repainting in formerly forbidden colors or installing the basketball hoops their children had been denied. Our larger share went primarily to establishing a community legal defense fund, ensuring that no future board could ever accumulate the unchecked power Margaret had wielded. The remainder funded a scholarship in Elaine's name at the local community college, supporting students studying horticulture and landscape design. Margaret herself disappeared from public view after the trial, reportedly selling her Aspen property to cover restitution payments. Occasionally, real estate agents would share rumors of her attempting to purchase homes in other HOA communities, only to be rejected when background checks revealed her history. 1 year after the verdict, on a perfect spring morning, I stood in our front yard beside my now thriving American flag, watching as children rode bikes down sidewalks that had once been off-limits to wheeled recreational equipment. Neighbors called greetings without lowering their voices, and gardens bloomed in gloriously non-uniform patterns across front yards, no longer subject to Margaret's tape measure. Elaine joined me on the porch, her wheelchair easily navigating the ramp that had started it all. "Do you regret buying here?" she asked, taking my hand. I considered the question carefully, thinking of all we had endured, the stress, the fear of losing our home, the constant battle against a system designed to crush individuality. "Not for a minute," I finally answered. "Sometimes you have to fight for a place before it truly becomes home." Behind us, the doorbell rang, the first guests arriving for the community's inaugural spring garden tour, starting, at the neighborhood's insistence, with Elaine's roses. I looked at the faces of neighbors who had become friends through shared adversity, at the children playing freely without fear of violation notices, at the home we had defended against all odds. Margaret had been right about one thing: standards did matter in a community. But she had fatally misunderstood what those standards should be, not uniform lawn heights or approved paint colors, but decency, fairness, and the right of people to make their houses into homes. As Elaine wheeled herself inside to greet our guests, I remained a moment longer, savoring the simple pleasure of a flag waving freely in the breeze, on a home that was truly ours at last. The end.